Hi, this is Jessica Newman Nelson. I'm doing my final assignment for Kaplan University PA105, the paralegal professional. Today I'll be discussing four types of law: statutory law, administrative law, constitutional law, and case law. I'd like to start with statutory law, which are written laws created by legislative bodies. These legislative bodies can be the United States Congress or state legislatures. They create these laws by submitting the ideas or thoughts for laws, possibly in the form of bills, that can then be voted upon and passed into law. A perfect example would be, for example, I live in the city of Hanahan. In the city of Hanahan, on any given school day, you cannot travel within a mile of the school driving in excess of 15 miles an hour. That's a city ordinance, and you can be written a ticket for violating that city ordinance. So again, statutory laws are written laws that are brought into law by being voted upon by legislative bodies. Administrative law is a combination of substantive and procedural law that gives power to government agencies to create statutes to regulate their specific areas. Federal agencies can be created either by the legislative branch, Congress, or the executive branch. For example, after the September 11th attacks on the World Trade Center, President George W. Bush issued an executive order creating the Office of Homeland Security. Administrative agencies are sometimes called the fourth branch of government because they are so large and numerous. And administrative agencies exist on the state and federal level. So you have federal agencies such as the Department of Homeland Security, as well as on state levels they have different agencies. For example, the state of South Carolina has the Department of Social Services, which handles welfare and different social issues in the state. The delegation doctrine allows the agencies certain delegated powers that fall under legislative, judicial, and executive powers. When administrative agencies act as a legislator by creating rules or statutes, then they can prosecute these violations of the statutes, thereby acting as an executive branch. Finally, they can rule in any disputes between two companies or two parties, which would be a judicial act. So basically, administrative law comes into effect by the agency having certain standards or certain statutes that, because they can then be prosecuted, become administrative law. Next, constitutional law doesn't really create laws, but it can strike down laws that are found to be unconstitutional. For example, Brown versus the Board of Education, the Supreme Court found that Ms. Brown's 14th Amendment rights were being violated because they were being separated because of race and the school system. So after Brown versus the Board of Education, schools were ordered to be desegregated because segregation was found to be unconstitutional. So basically didn't really create any new laws, but struck down laws that were found to be unconstitutional because they violated someone's constitutional rights. Case law, on the other hand, creates laws by forming a precedent. And basically a precedent is stating that if the same facts in the same situation were to occur in another case, that there would be some predictability of the ruling of the case because a precedent has been set. So by handing down judicial opinions, the court interpret decisions into interpretations of statutes constitutional provisions and administrative regulations. Case laws are often published in law reporters. Um, a prime example of this would be when